The right to mediation. The Children and Families Act 2014 sets out when parents and carers and young people have the right to mediation and what it can be used for. Many parents and carers question if they should participate in mediation or go straight to appealing to the SEND tribunal. This is not a question we can answer because it is their choice to make. It is now taking as long as a year in some cases for an appeal to the SEND tribunal to be heard. So more parents are deciding to give mediation a go. Although taking part in the mediation will delay the point at which the parent, carer or young person can submit an appeal, it has the potential to resolve all or some of the issues that are in dispute much more quickly. Mediation might result in the local authority agreeing to make some changes to the EHC plan. If this has happened, but the parent, carer, young person was still unhappy with some of the aspects of the plan, an appeal to the SEND tribunal could still be brought. Even if an appeal is submitted, as long as the written agreement resulting from the mediation session clearly sets out the local authority's agreement to amend the plan, the local authority are legally required to issue an amended EHC plan within a set time frame. The time frame will depend on whether the local authority's agreement was just about the school named in the EHC plan, in which case it will have 2 weeks to comply, or whether changes to section B and F of the EHC plan was agreed, in which case it will have 5 weeks to issue an EHC amended plan. If there is a different time frame included in the mediation agreement, this is perhaps because the situation is urgent, the local authority will have to comply with this. Mediation is also available when the local authority has refused to carry out a needs assessment or issue an EHC plan. And even if mediation doesn't result in the local authority changing its mind, through mediation it is possible to achieve some improvement to a child or young person's situation. For example, a local authority may be able to agree to provide some temporary funding to the school or to send in an education psychologist or other professional to carry out observation or provide advice and support to the school. Again, it will be important to make sure that what the local authority has said it will do is recorded in the mediation agreement. The local authority will then be required to carry it out within 2 weeks unless a different deadline is agreed. You will find the details of the mediation service on your right of appeal letter. It would be for the parent or carer or young person to make contact with the mediation service and to arrange a date for this to be held. The mediation service will contact the local authority on your behalf to arrange the mediation and also contact any other professionals involved in your child or young person's support who they feel can contribute and help towards the mediation. The RIAS website has more information on mediations, and you can also arrange a meeting with one of our advisors who would be happy to talk through the process with you.